In this lesson, we want to focus on relevance under Rules 401, 402, and 403 of the Federal Rules of Evidence. So, if you remember from our last video, right, we said that our primary objective or goal on an evidence fact pattern is going to be to determine whether each piece of evidence in the fact pattern is admissible or not admissible, right? This is what we're trying to get at. This is the primary goal on an evidence fact pattern. We're trying to determine the admissibility of each piece of evidence. And remember, we said that the gateway issue or the gateway question, the first hurdle that each piece of evidence has to get over to be admitted into court is this idea of relevance. Rule 402 of the Federal Rules of Evidence tells us that irrelevant evidence is not admissible. Or in other words, right, to be admissible, evidence must be relevant. This is always our starting point rule for each piece of evidence, right? So as we go through an evidence essay and we're trying to analyze each piece of evidence and determine whether or not it's admissible in court, our first hurdle we need to discuss is whether the evidence is relevant, right? We're going to use what you see here on the board to make that determination. But before we jump into it, as a final note, just one more thing to point out is that just because we find evidence is relevant, that does not necessarily mean that the evidence is automatically admissible in court. Remember, it's just the first hurdle the evidence has to get over, and there could be several other hurdles, right? So just because evidence is relevant doesn't mean it's automatically admissible in court, right? It's just the first hurdle of what is likely going to be several hurdles the piece of evidence has to get over to be admitted, right? So how do we make this first hurdle determination though, right? Relevance. Well, we're going to start with Rule 401 of the Federal Rules of Evidence. Sometimes you'll hear this referred to as logical relevance. And Rule 401 states that evidence is relevant if it is both probative and material, right? Probative meaning that the evidence has any tendency to make a fact more or less probable than it would be without the evidence, and material meaning that the fact is of consequence in determining the outcome of the action. If both of these elements are satisfied, we say that the evidence is relevant under Rule 401 of the Federal Rules of Evidence. So we're going to break these two elements down with some examples, but the key here to recognize from the outset is that most evidence is going to be logically relevant, right? Why would a party be trying to admit irrelevant evidence, right? The whole goal here, remember, the jury is the fact finder. We're trying to present facts to help the fact finder determine what actually happened, what the facts of the case are. So if we're presenting evidence that doesn't have any tendency to make a fact more or less probable, for the most part, that's not going to be beneficial to either party, right? So why would we be wasting time in doing that? Most of the time, right, evidence is going to be relevant under 401. Otherwise, why would the party be admitting it? But we'll talk about some cases where it's not going to be relevant, but just for our purposes in the back of our mind, we want to remember that 401 is a very low requirement, right? Most of the time, evidence is going to satisfy the two elements of Rule 401, right? Because the operative word, right, if we're going to break each of these elements down, right, our first element we're thinking about, does the evidence have any probative value? The operative word here is any, right? If the evidence has any tendency to make a fact more or less probable than it would be without the evidence, we say it has probative value. So let's keep an example here. Let's come up with an example. So what I like to use here is something that's very binary. So let's say that we have a car accident, right? The defendant or the plaintiff is alleging that the defendant has entered an intersection when the stoplight was red, negligently causing a car accident, right? So the whole case rests on the color of the stoplight. And let's, to keep this very simple, say we're in a closed universe where either the light is red or green. Let's say that there's no yellow light and let's say that there's no chance that the light wasn't working or something like that. So there's a 50% chance the light was green, there's a 50% chance the light was red, and that's what the entire case rests on, right? If the light is red, the plaintiff is going to win. If the light is green, the defendant is going to win, right? A very binary case, right? And normally it's not that straightforward, but just to illustrate relevance, let's roll with this, right? So here, the first question would be, and let's say that I am a witness, right? I am at the scene of the accident. I am a witness to this, and I am going to come to court and testify, right? My testimony is going to be used as evidence, okay? And I'm going to recount what I saw at the accident. So let's say I take the stand and I am asked what color the light was, right? Doesn't matter which side is asking me, I am asked what color the light was when the defendant's car went through the intersection. Well, let's say that I get up there and I say, hey, look, it was a long time ago. I don't remember it fully. You know, I only got a quick glance at it. I could be wrong here, but I think the light was green, right? Well, does that testimony, does that evidence have any tendency to make the fact that the light was green any more or less probable than it would be without the evidence? Well, here again, the operative word is any. That might not be very strong evidence when I'm saying stuff like, I don't remember that well, it was a long time ago, it was dark outside, I only got a quick glance, but nonetheless, I think the light was green, right? Well, all of that other stuff goes to the weight of the evidence, and the jury can decide what they want to value that evidence as. If they're going to value that as strong or weak, right? That's for the jury to decide. But what we're asking under 401 is if that statement has any tendency to make the fact as to what color the light was any more or less probable than it would be without the evidence. So if we know that it was a 50% chance, right? If we remove my testimony, right, and we're just looking at this fact pattern, everyone knows, right? Remember, in our closed universe, there's a 50% chance the light is red, there's a 50% chance the light is green. Has to be one or the other. So without the evidence, we know it's a coin flip. It's 50-50. Well, now we've just added testimony where someone is saying, hey, I think it was green. So even if that only shifts it, you know, the 50-50 to 51-49, now we think it's 51% chance that it was green, 49% chance it was red, that tiny little shift, right, is enough to equal satisfaction of this first element, right? Because the operative word is any. That has some tendency, even if it's tiny, to make the fact that the light was green more probable than it would be without the evidence, right? So oftentimes what we'll find with testimony, right, and when someone's under penalty of perjury, rarely you do see it, but most of the time, right, witnesses don't really want to fully commit to anything. You're going to get a lot of witness testimony along the lines of, hey, I can't be certain, you know, it all happened so fast, to the best of my memory, this is what I think happened, right? You're going to get a lot of that type of testimony when someone's under penalty of perjury. And that's all fine, right? All of that, it doesn't matter what you really preface it with, if it has any tendency to make the fact more or less probable, we say it has probative value, and this first element is satisfied. Right? So that's the key to remember here. So where would it not have any tendency to make a fact more or less probable? It's actually hard to come up with fact patterns where evidence doesn't have any tendency to make a fact more or less probable, but it would have to be pure speculation, right? Somebody's actually going to get up there, I take the stand and I say something like, hey, you know what? I wasn't looking, I had no idea what the light color was. You know, they ask me, the lawyer asks me, hey, what color was the light? I say, at the time that the defendant drove his car through the intersection, I'm like, hey, I wasn't looking, I have no idea. There's a 50% chance that it was green, 50% chance it was red, I have no idea. Well, in that case, right, if we removed my testimony, right, that we're in the same place we were before. It was a 50-50 chance before I testified. It's still a 50-50 chance after I testified. My testimony added nothing in terms of adding or having any tendency to make the fact as to the light color any more or less probable than it would be without my evidence, right? So that's the test. Basically, you just ask, if we removed this testimony or if we removed this evidence, are we in the same place we were before, or do we get something out of it, right? So as long as there's something, right, it moves the needle 1% either direction, we're going to say it satisfies this first element. Okay, but that's really enough there. You just want to look out for something that is just purely speculative, or, you know, I had a dream the night before. Yeah, the light was red. I had a dream the night before that the light was red. That's how I know. Right, well, right, because you had a dream the night before, that's not going to have any tendency to make the fact more or less probable. Again, though, very low threshold. Someone says something like, I think the light was red, that's enough, okay? So usually what the harder question is in this analysis to get over is this idea of materiality, right? Is the fact actually of consequence in determining the outcome of the action? Well, in this case, it's very easy, right? In facts that are always material, just to give you some baseline here, the credibility of witnesses is always material. That is always of consequence in determining the outcome of the action. Elements of the crime, the claim, or an affirmative defense is always material. Those facts that shine light on any elements of the crime, the claim, or an affirmative defense are going to be of consequence in determining the outcome of the action. Anything revolving around or shining light on damages in civil cases is going to be material. Those types of facts are going to be of consequence in determining the outcome of the action. These are really your big three, though, right? Anything that goes to the credibility of a witness, an element of the crime, claim, or defense, or damages in civil cases, right? These are all very material facts. So in the example we're using, if I'm testifying to the color of the light, well, that's the heart of the case, right? That's the element of the claim. That goes to the very heart of the case. Clearly, my testimony is material, right? Even if I say, hey, look, I think the light was green, can't be sure, right? Well, that would be relevant under 401. That's clearly, it has a tendency to make the fact of the light color more probable than it would be without the evidence, and the fact is of consequence in determining the outcome of the action, right? The color of the light is the center of the case. It's about as material as it gets, right? So let's say, though, to illustrate materiality, right, the second element, that I take the stand and the lawyer asks me, what did you have for breakfast the morning of the accident, right? And I say, well, I had a stack of pancakes. Well, does that testimony have any probative value, right? If we're asking the question, is that testimony relevant? Well, we start with element number one. Does that statement that I ate pancakes the morning of the accident have any tendency to make a fact more or less probable than it would be without the evidence? Well, yes, sure, right? My eyewitness testimony that I ate pancakes the morning of the accident has a tendency to make the fact as to whether or not I ate pancakes more probable than it would be without the evidence, right? Without the evidence, we have no idea what I ate that morning. With the evidence, you know, we can have a tendency, right, at least to know that I had pancakes that morning. So that eyewitness testimony does have a tendency to make the fact as to what I ate for breakfast that morning more probable than it would be without my testimony. Right, so the problem here is going to be, does what I ate for breakfast that morning, is that a fact of consequence in determining the outcome of the action? Does that go to my credibility as a witness? Probably not. Does me eating pancakes that morning go to an element of the crime, claim, or defense? Probably not. Does it go to damages? Again, probably not, right? So me eating pancakes the morning of the accident would probably be immaterial, right? It would not be able to satisfy the second element. That's not a fact that is of consequence in determining the outcome of the action. So we would say my testimony that I ate pancakes the morning of the accident is not relevant under Rule 401 of the Federal Rules of Evidence. Now, of course, we could make it relevant with the facts, right? If we made it go to it doesn't matter, right? Credibility as a witness. Let's say that I have a severe allergic reaction to pancakes, right? If I eat pancakes, it causes me to have all kinds of symptoms, including blurry vision, right? Let's say every time I eat pancakes, I have an allergic reaction, and one of the reactions I have is blurry vision. Well, now, right, whether or not I had pancakes the morning of the accident is material, right? That is now a fact that is of consequence in determining the outcome of the action. That goes directly to my credibility as a witness, right? We call that sensory competence, right? My ability to see goes to my credibility. So in that case, if I have an allergy to pancakes that could affect my vision, now that fact is material, right? So that would be relevant under 401. Right, so it's all fact specific, and you can see how this goes both ways, but the key to recognize on both of these elements is that the threshold is 1%, right? If it's 1% probative, that's enough. If it's 1% material, that's enough, right? We say with materiality, even if it's one brick out of a huge brick wall, that's enough, right? That's the metaphor you often hear. It's okay. It doesn't have to. The fact itself does not have to, by itself, prove the entire case or an element of the case. It could just shine light on one small brick of the case, of a huge brick wall, right? The threshold here is very low. So again, your big three when you're thinking material facts are credibility, elements, and damages. But remember, any fact that shines light in almost any way on any of these three things is going to be enough. We don't need the whole brick wall, right? As long as the fact is a brick in that wall, it's going to be enough to satisfy 401, right? So that's why I said at the beginning, most of the time you're going to find evidence is logically relevant, unless you're dealing with something, right, that's just completely illogical, basically, right? It just, someone's getting up on the stand and is just being so non-committal or so speculative that it has no tendency to prove anything, or the fact is just completely in left field. It has no bearing on the case at all. It's not a fact of consequence in determining the outcome of the action. But you can see most of the time, right, it's going to satisfy both of these elements, okay? So 401 should be a relatively straightforward analysis. At the end, we'll talk about a couple of situations. We're going to go through 403. At the end, I'll circle back and talk about a couple scenarios where 401 can get a little bit tricky, but that'll be kind of a preview for our next video. But for now, hold off on that. Let's just briefly talk about 403, because this is immediately what you should think of after your 401 analysis. So again, as a big picture refresher, on an evidence essay, right, you're going through each piece of evidence, trying to determine whether or not each piece of evidence is admissible. Well, we know our gateway is 401. Is it logically relevant? Each piece of evidence, we want to determine whether or not it's probative and material. We go through our elements under 401. The first check on 401, right, after we determine a piece of evidence is relevant under 401, is 403, which sometimes is referred to as this idea of legal relevance. And this is really kind of a check and a balance on Rule 401, right? Because remember our threshold here. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern. Hi everyone, my name is Michelle and I am a first-year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.